Hello, ladies and gentlemen. I have been asked by the spirits of the dead to introduce to you Dermot Hannigan, who will talk on our behalf, because we're not here to communicate, about our feelings about the Succession Law Reform Report in Victoria. As we see this as an insult to the spirits of the dead and to what we have produced in life. So please, I hand you now over to Dermot Hannigan, who will discuss this report on our behalf.
The review of our Succession Laws Report by the Victorian Law Reform Commission. The review of our Succession Laws Report has now been completed by a panel comprised wholly and solely of lawyers. Not one person to represent families or our community with so much wealth at stake. I wonder why. It should be noted that one of the members of this panel was the past president of the Law Institute of Victoria, the Lawyers' Union. The other member, Richard Bowden, barrister from Jardine's Chambers. Another member of the committee, Professor Prue Vines, has written a paper named Bleak House Revisited. Thus I would assume the members of the committee were fully aware of the tragic wills dispute described in Charles Dickens' novel Bleak House, which describes the longest running wills case in history that lasted 120 years, until the lawyers consumed all of the estate. The terms of reference clearly state that the objective of the review is to ensure that the law operates justly and fairly and in accordance with community expectations in relation to the way property is dealt with after a person dies. Our current laws have provided the legal profession with an enormous feeding ground that extracts money from vulnerable families and benefits the pockets of lawyers. In Victoria, approximately 40,000 people die each year, leaving an estate worth an average of at least $500,000, an amount of $20 billion per annum. The legal industry is entrusted to transfer this wealth from the dead to the living. The current process is inefficient, expensive, unaccountable, and full of deceptive procedures that allow lawyers to hide important information from family members. It's a system that has evolved through time and has developed by the legal industry so as to obtain maximum benefit for themselves. At a 10% average processing cost by the legal profession of deceased estates, this amounts to an annual contribution of at least $2 billion. In revenue for the legal profession. There are 16,000 lawyers in Victoria, about half would be employed in areas that would not share in the feast. If we say 8,000 lawyers share in $2 billion, that calculates out to $125,000 per lawyer per year, a significant component of plunder for the legal industry. This review put out by the Victorian Law Reform Commission report on our succession law reform has the gall to state, in Views and Conclusions 1020. At the general level dealt with in this chapter, the Commission considers that cost rules in their application to succession proceedings are working satisfactorily and do not require legislative amendment. The Commission has received no submission expressing a contrary view. I am not sure how the Law Reform Commission interpreted my submission. Where I have suggested that the review realise the success of the campaign on Make War on 1034, which was all about reducing the death rate on our roads in the early 70s. This submission compares the culture of a car driver in the early 70s to that of a present-day lawyer executor who is driving an inheritance vehicle, probate being the driving part. I have recommended the law reform process address the issues of human rights, policing and standards, so as to assure the owner of the inheritance, the deceased, and its passengers, the beneficiaries, that they will be safely transported by the driver, the lawyer executor, and minimum damage will occur to the vehicle, the estate. I would assume this means making sure the process did not erode the value of an estate, which means looking at the costs of the whole system. The new laws should address this disgusting situation, but unfortunately the recommendations from this report do nothing of the sort. To appease the worst case and most obvious aspects of these unfair laws, the committee made up of lawyers has recommended that lawyers who are acting as executors should be incorporated into the Legal Professional Act, which would allow the Legal Services Commissioner to investigate complaints by beneficiaries against their behaviour. Behaviour, mind you, that it can involve theft and fraud, that can involve a very large sum of money. We should all now feel safe as the Legal Services Commissioner receives 7,000 telephone inquiries about bad lawyers every year. They're able to discourage 5,000 of those complaints over the phone and only receive 2,200 written complaints. Of the written complaints, they either mediate or find that 2,000 of those complaints have no merit and only investigate or prosecute 200 complaints. The Legal Services Commissioner only investigates amounts below $25,000, which is a pittance when it comes to deceased estates. In other words, we are going to use a broken system to fix a very serious problem that involves systemic robbery of our family inheritance. This recommendation is a furphy, as lawyers who are executors should have always been bound by the Legal Professional Act of 2004, because if they were not bound, they would be contravening the Trade Practices Act of 1974 by advertising their services to customers as lawyers when knowing full well that when acting as executors they would not be bound or regulated by lawyers' rules. In other words, misleading and deceptive conduct of their services to naive customers, knowing full well that the consumer would be dead when the services were provided and would be unable to complain. The review has also recommended that the Law Institute of Victoria write the guidelines for these lawyers who are executors, as they can be incorporated into the Legal Professional Act of 2004. A bit like asking Dracula to write the rules on how to manage the blood bank. At least they have admitted to their negligence. There is nothing in this report about creating quality standards for lawyers who act as executors, making the process more efficient, or incorporating the philosophy of human rights into the law. Family development and culture do not even rate a mention in this review. A review of our inheritance laws that will determine the way this nation develops over the next 100 years. The recommendations of this review as regard to lawyers who act as executors is indicative of a legal system that allows unaccountable lawyers to write the laws and interpret and administer the laws for their benefit instead of it being made in the interests of families and the development of our nation. There is nothing in this review that mentions executors who are lawyers' responsibilities to share important information with beneficiaries, family members, as is mentioned in the National Review of Unifying Australia's Inheritance Laws. Transparent communication between a lawyer executor and a family is an essential component for avoiding disagreement and reduces legal costs to the estate. Nothing about capping the legal costs on a deceased estate. After all, it's not rocket science. The Victorian Law Reform Commission's report on our succession law reform suggests that the County Court be responsible for administering small estates with a value of less than $500,000, leaving the major proportion by value of deceased estates to the administration of The Victorian Law Reform Commission's report on our succession laws suggests that the County Court be responsible for administering small estates with a value of less than $500,000, leaving the major proportion by value of deceased estates to the administration by the far more expensive Supreme Court. Why has the value of a small estate been determined at this amount instead of, say, $2 million? The Law Reform Commission, in its review of succession laws, could quite simply have stated that all lawyers who act as executors are obliged to Australian consumer law, and that beneficiaries of deceased estates are consumers of their services, as should always have been the case after the Trade Practices Act of 1974 was enacted. Instead of perverting the course of justice by running around the Legal Professional Act of 2004, which is just another smokescreen by the profession to avert their responsibilities to Australian consumers of their services. The report has stated the following with regards to consumer rights of beneficiaries. Personally, I would have expected such a well-resourced committee to have been able to have made a determination. Comes in under other legislation 7.2. Although the Professional Act imposes obligations on legal practitioners when providing legal services and avenues for resolving disputes and complaints, the Australian consumer law also applies to the legal services they provide. However, it is not clear that a beneficiary would have standing to make a complaint about legal costs charged to the estate, as the estate, not the beneficiaries, is liable to pay. In any event, it is likely that any conduct that contravenes the customer service guarantees under Australian consumer law will be behaviour for which the legal practitioner can be disciplined under the Legal Professional Act as well. Now, I'd like you to think about criminal provisions. I would consider it an act of negligence by the Commission not to have discussed or recommended how criminal provisions of the two acts that apply in Victoria to some lawyers who are executors should be allocated the necessary resources for any investigation that may be required under the following criminal codes. Now, the Crimes Act of 1958, Section 86. A person who dishonestly, with a view to gain for himself or another, or with intent to cause loss to another, destroys, defaces or conceals any valuable security, any will or other testamentary document, or any original document of or belonging to, or filed or deposited in any sort of justice or any government department is guilty of an indictable offence and liable to level 5 imprisonment, 10 years max. Administration and Probate Act of 1958 provides concealment of a will, a misdemeanour. Every person who retains or conceals or endeavours to retain or conceal any will or codicil or aids or abets any person in such retention or concealment with intent to defraud any person interested under such a will or codicil shall be guilty of an indictable offence and shall be liable to a fine of not more than 100 penalty units or to imprisonment for a term of not more than 2 years. Now, I was involved in a case, and I've seen quite a few, where the lawyer executor was able to conceal very, very important information from the family member executor and from all of the beneficiaries. And finally, when that information was discovered, was found to have lied. Now, he was able to conceal that information because he said it was legal client privilege. That is, he had privilege over the documents even though the person had died. And that's a criminal act because he conceals the wishes of the dead. But none of our regulators, that is the Legal Services Commissioner, the Ombudsman, or Consumer Affairs Victoria, will prosecute. And this came from the law firm Russell Kennedy's and a gentleman called Ian Bald, who was supervised by a barrister, a wills expert, called Arthur Bolkers. You're all very, very high up in the legal profession. I can empathise with the members of the Commission and realise it is not intentional, as they are only familiar with the workings of a medieval structure that they believe in. Unfortunately, because all members of the advisory committee were sourced from people with a legal background, they believe that all lawyers are honest, and therefore there is no need to create a system that catches and punishes the thieves amongst the profession. This leads to the one bad apple syndrome. Why was there not a strong contingent of representatives from the wider community placed on this very important committee? Unfortunately, you cannot build a strong and sustainable product using medieval systems. It does not work. It appears as if the Law Reform Commission believes the system is working well, according to community expectations, and with a few tweaks and some minor modifications, the community's expectations will have been met, and we'll all get back on the horse and cart. The reason that this has occurred is because our legal system has grown from a convict settlement, a settlement that was stripped of culture and had no recognition of family as the core and fundamental component of our society. Until the law reform process is changed and culture and families are given the positive positions of influence and power, when law is constructed, our nation will remain a prison that is controlled by greedy, self-serving and unaccountable lawyers, whose sole purpose in life is to feather their own nests. At the beginning, I mentioned 2 points about 2 members of the advisory committee. The first was that one of the members was an ex-president of the Law Institute of Victoria. The reason I feel is obvious. The legal profession needed one of their own to report back to the Central Committee to ensure that their income stream is well protected from any recommendations of law reform. The second related to Richard Bowden, barrister from Jardines Chambers. Jardines versus Jardines was the fictional name used by Dickens in Bleak House to describe the longest and most expensive wills case that ran for 120 years and eroded the whole of the estate in legal fees. For any person who has been a victim of legal abuse in a deceased estate, this pointed to the hubristic culture of the Victorian legal profession, both by calling a barrister's chambers by this name, and worse still, appointing a barrister from these chambers to sit on a review committee on succession law. It is a reasonable if, as a responsible member of our community, you do not believe in the she'll be right attitude, trust us, projected by our legal profession, stand up against this travesty and ensure that these recommendations by the review panel of Victoria's succession laws are seen for what they are. She is wrong, and help influence the debate so as we do end up with succession laws that represent our community's needs, expectations and culture, instead of meeting the needs of the legal profession, a profession that has become far too powerful and have proved time and time again that they cannot be trusted with the shaping of our nation to benefit our culture and our families. I trust you will see through the veneer of trust projected by the legal profession and join with us by using your influence to help protect the future interests of Australian families. We have a once-in-a-100-year opportunity to reshape our legal profession through succession law reform and make them provide our community with a low-cost, inefficient and accurate system that has a culture of collaboration, truth, transparency and trust incorporated into its structure, where culture and the input of community and family are very much participants when it comes to reshaping our laws, and where the legal system becomes accountable to Australian consumers For more information on how you can participate, just Google lawyers or grave robbers.
I am the parliamentary draftsman, and they tell me it's a fact, and they often make a muddle of a very simple act. I am the parliamentary draftsman, and they take me in their stride. Oh, how nice it is to do a job that I will never have to try.